Welcome everyone, and thank you very much, Lisa, for the introduction. Yes, the talk is going to be wrong on many levels, understanding crimes across and between events. Just before I begin, just a quick thank you to particularly sort of colleagues, past, present, many of whom are here today, and particularly co-authors. Anyone who's familiar with my work will know that a large proportion of it tends to be worked with co-authors, and I've got a lot out of that, be it in sort of criminal law theory or in neuroscience and so on, and they're truly like wonderful people within a 5-minute walk of my office. In terms of the talk today, so I'll go into this idea of crimes between events, right? But I just wanted to explain, first of all, the kind of the wrong on many levels was also a bit of an excuse to retell a joke from a sort of sadly departed friend and former PhD supervisor, Professor Rob Cryer, who used to tell me often after a few drinks that his, inverted commas, criminal law joke, which was, what's wrong with crimes taking place on a multi-story car park? They're wrong on many levels, which is not the best joke, but I do think he would appreciate it getting another outing in an environment like this one. So, okay, the idea then of this sort of across and between events. The way to start really is to first of all think about the sort of the paradigm of crime. Yes, there is a chart. The sort of paradigm of what we think about as criminal offences, and this is the so-called single event offence. So, simple offence behind me is the one of criminal damage. So we think about the actus reus, that's the sort of physical outward parts of the offence. We need any kind of conduct from the defendant that leads to damage to property, the circumstance element being that that property must belong to somebody else. We then have corresponding mens rea requirements, that's the mental elements of the crime. So the conduct of the defendant must be voluntary, they must know or at least be reckless as to the fact the property belongs to somebody else, and they must intend or at least be reckless to causing that damage. So all of that, all of those elements are very much focused around the event, which is the conduct of our defendant, and they're all defined in relation to that point of conduct. So when we think about the actus reus elements, we're talking about circumstances at the point of the conduct. When we talk about results, we're talking about things caused by the defendant's conduct. And similarly with the mens rea, voluntariness, knowledge, recklessness, intention must be at the time of the defendant's conduct. That's our focus. Even incidentally, if the result itself happens sometime later. So you can imagine where a defendant plants, let's say, a time bomb that explodes many hours later. It doesn't matter if they have remorse during that time, phone the police, say, this is what I've done, they desperately hope that it doesn't explode. If it does explode and it causes damage, then they've still committed criminal damage because they had the requisite intention at the point that they planted the bomb. It's at that point of conduct. That's our focus. Now, this is often referred to as the contemporality principle, and there are sensible reasons why we have this within the law. There are normative reasons in the sense that we blame our defendant for what she does, for her reasons in action. So it's about our interaction with the external world and why we make those interactions. We don't blame people for accidents, we don't blame people for mere thoughts. It's about their conduct, their external contribution. There are also practical reasons for this. We don't think about the criminal law as a judgment of someone's character or an amalgamation of their conduct, good and bad, across their lives. We need something that's manageable for a criminal justice system. So both in terms of placing the crime in time and in space, jurisdictionally, and indeed making it manageable for the courts, for the police, to have an event that is the point of focus. Now, this structure, this sort of paradigm of criminal offence building, and this is the paradigm of offences throughout the so-called special part, the part of the criminal code which is defining individual offences. Now, understandably, this also becomes our focus when we're thinking about the building blocks of crime, when we're thinking about theorising crime. So when we talk about defining these terms, voluntary, knowledge, recklessness, intention, causation, we talk about and we define these terms in criminal codes and in the common law based on that paradigm of a single event offence. And this is essentially the problem. So when you move on to the exceptions from this single event structure, this is where you begin to have issues. Now, there are exceptions within criminal defences, and I'm not going to focus on those. So for those of you familiar with this, you'll often have a two-part structure with a criminal defence. So for self-defence, yes, our defendant has committed a crime, but you're allowed to look back and say, okay, they only did that because they were attacked. So that T1 offence, time one attack, time 2 offence, we're allowed to look back in terms of exculpation. Similarly for duress, yes, I committed a crime, but I only did so because I was threatened at time 1. Only then did I commit the crime at time 2. Now, that structure is not particularly problematic because we're not merging time 1 and time 2. We're looking at them at separate events. What happened at time 1 is significant in terms of excusing or justifying what happens at time 2, but we're not looking at merging them together. Where we do have problems is where in relation to offences, where we do start merging sometimes what happens at T1 and T2 to understand offences. This is true of inchoate offences, so our defendant attempts or conspires or assists or encourages at time 1 with the intention or with other kind of mens rea as to an offence in the future. Complicity, where I assist or encourage you to commit a crime and at T2 that crime must in fact be committed. And so-called prior fault. This is where a defendant at time number 1 creates circumstances which lead to, for example, a lack of mens rea or a lack of mental fault at time 2, and we're constructing a crime across. We'll deal with each one of those in turn, so I'll explain them in a bit more detail in a moment. But what is noticeable about each of these 3 areas is they're some of the most problematic areas within the criminal law. When we talk about inchoate offences, we're often talking about the limits of criminalisation, the first point at which you cross the line into committing an offence. You're not yet necessarily causing a harm, but you're trying to cause a harm, you're agreeing to cause a harm, you're assisting and encouraging others. So we have that controversy about those lines of criminalisation. In terms of complicity, we're talking about group criminalisation and the issue of what's often referred to as liability by association and associated problems there. And in prior fault, we've got an area which is really under-theorised, or at least there's a lack of understanding in the courts, where eventually we tend to get a lot of statements in the courts which is just about putting order or justice ahead of so-called legal principle, which is set to one side. So in each of these areas, we have real problems. And that's what's enticed me to each one in terms of the work that I've done so far in my career. Now, incidentally, they're often seen as problems, but not necessarily linked problems. They're often seen as bespoke or distinct within each of those areas. And indeed, that's how I've come to them as well in my work. So this isn't a thesis that I've developed and then sought out to prove throughout my career, but it's one of those ones of kind of researching forwards and understanding backwards. That where I've looked at each one of these areas, and I tend to look at crimes and critique in terms of the structure of them, what I've noticed, and particularly in the last few years, is that the structural problems I've encountered in each one of these 3 areas is really very similar. And that sort of gets me on to the thesis that I want to explore in this lecture, which is essentially that when we look at the problems for inchoates, complicity, prior fault, and others, we can't really begin to understand those problems, and we certainly can't begin to solve those problems or engage them in reform until we understand some of the common structural problems associated with the fact that these are not single event crimes, that these are crimes which involve multiple events, and I'll talk to you about why that's important. Okay, so as I say, we'll go through each of them and hopefully add some sort of flesh to that. First of all, in relation to the general inchoate offences. So for those of you less familiar, we're dealing with attempts, conspiracies, and assisting and encouraging. An attempted offence, as you can see behind me, our defendant goes beyond mere preparation to commit a crime, and they have to have the intention that that crime should actually happen. For conspiracy, we're dealing with 2 defendants who agree with one another to commit a crime in the future. And for assisting and encouraging, we're dealing with a defendant who, as the name suggests, assists or encourages another party to commit an offence in the future. Now, for each one of these, we're dealing with this T1, T2, which is time 1, time 2, 2 separate events. Our focus for the general inchoates is that first event, where I am attempting or agreeing with you in conspiracy or assisting and encouraging. That's the point where my conduct has to be of the relevant kind. But I must also have a mental element in relation to the future T2 offence, which I want to bring about, or I'm agreeing with you to bring about, or I'm assisting and encouraging you to commit. So it's understanding that bridging between the T1, our activity now, and the T2, what I want to happen in the future. And this is one of those, the unique 2-event situation. Now, there are a couple of problems here. The first one, and this is what is often dominated much of the debate, and I spent a long time working in this area, which is actually understanding about what the elements are of these crimes that we're dealing with, particularly in relation to inchoate offences. So the debate is often one about what mental state at time 1 must the defendant have in relation to that crime taking place at T2 or potentially taking place in the future. Now, the traditional approach has kept things quite simple. Traditionally, certainly for attempts and indeed for conspiracy still and assisting and encouraging until relatively recently, the defendant had to act at T1 with the intention that that future offence should happen. So if I'm agreeing with you that we're going to commit criminal damage, if you think back to the sort of 6 elements of criminal damage which I showed a moment ago, it would simply be that I had to intend every single element. 1 to 6 would have to be intended. And only if there's that intention at T1 as to all of those future elements of the crime would the offence be committed. But this became complicated, particularly in 1990 with the case of Khan. So Khan was an attempted rape case where the defendant was found to have intended most of the elements of the crime, but they were merely reckless as to a lack of consent for the victim. So the issue was, if we apply the traditional approach of requiring intention as to every element, then there would be no liability in that case, because the defendant didn't intend a lack of consent, which would be element 2, and because they didn't intend it, that would seem to undermine liability. However, that seems rather under-inclusive, and indeed the court felt that that was rather under-inclusive. And at the Court of Appeal, they said, OK, the statute says we must intend for attempt, but it's actually enough that you intend the act parts and the result parts, and the circumstance bit of the future offence is something that can mirror whatever's required for that offence itself. So essentially, they found a way of finding liability in that case. But in doing so, they created a point of complication. Now, in order to understand what the mens rea is for an attempt, you have to be able to distinguish what is the act, circumstance, and result element of that future offence. Because for certain elements, you have to intend them. For the circumstance element, you're allowed to mirror whatever the principal offence requires, so it may be different. Now, that's problematic at the best of times, trying to really understand how do we split all crimes into this structure. But it became particularly problematic in a case called AG reference number 3 of 92, catchily named. It was a case which involved a defendant who threw a petrol bomb at a moving car, missed the car, the petrol bomb exploded by a wall. The offence charge was an attempted aggravated arson offence. So the arson part of that is pretty straightforward, attacking with fire. But the aggravated part of the offence requires that our defendant was reckless as to the endangerment of life. So the debate there became, what is this requirement? Reckless as to the endangerment of life. Is this a circumstance or is this a result? Because if it's a circumstance, then recklessness on the part of the defendant would be enough. But if it's a result element, if it's something that's causal, then it has to be intended, of course, because of Khan, and therefore there wouldn't be liability. Now, the Crown Court said that this was a result element. Reckless as to the endangerment of life sounds like it's something you're doing, something you're causing, the endangerment of life, so they said it's a result element, therefore there's no liability. The Attorney General referred that to the Court of Appeal because there was a fear that that was the incorrect interpretation of the law, and indeed the Court of Appeal said that was wrong, that there should have been liability here. Incidentally, they said there should have been liability, and they used an approach by an academic, John Stannard, which is problematic for other reasons. But what that led to was a debate within the literature about should this element have been conceived as a result or as a circumstance. And that was debated in Law Commission reports, in seminal textbooks, and various academic articles. And that has been, until very recently, very much the focus of that debate. So my point on this was actually it doesn't look like it fits either of them. It's not a result, it's not something the defendant causes because it's purely mental. There's no requirement that they actually endanger life, it's just that they have to foresee the chance of endangering life. But equally, that's not a circumstance, that's not a fact that goes alongside the action. Again, it's something mentally that the defendant is trying to achieve. So in my work, I've looked at the idea that actually when we talk about ulterior mens rea, this is mens rea that goes beyond the actus reus of the crime, sorry for those of you less familiar, this should be conceived as a separate element and therefore debated about what mens rea we should require as to that element in a separate way. So this is getting to the heart of why structure matters. Without the identification of this as a separate issue structurally, we're stuck in an old debate, which is circumstance equals recklessness, result equals intention, which one is it? The development here is the idea that actually if we conceive of this as something different from that, then structurally we don't have to fall into that old debate, and in fact what we should be discussing is what mens rea should be required for an attempt, for a conspiracy and so on, in relation to an ulterior mens rea element. And again, that becomes particularly problematic. The graph gets a bit silly there. But this is about so-called infinite inchoate liability. So someone who conspires to assist or encourage or attempts to assist and so on. And the point here is, as I discussed in one of my earlier papers, that my argument was that this should be an intention requirement. But the major point of that is not so much my view that it should be intention, you can argue something different, but is the initial structural point that we were debating the wrong thing before. So it's understanding structure as a way to then understand where normative debates should be held. The next problem I want to look at is associated, but actually is much more significant than the first. So the problem here, and this is one I've only really come to in recent years, particularly working with Adrian in the front there, is that essentially when we talk about mens rea terms, so back to those sort of classic mens rea terms, the mental elements, intention, knowledge, recklessness, and so on, they are defined, as I said, quite sensibly and understandably in relation to the paradigm of a single event offence. But actually when we look at those definitions of those mens rea terms and we apply them to multi-event offences like the Inchoate offences, the definitions simply don't hold up, they don't work. And this is a much more important problem because whereas the last one I addressed is really only an issue if you're trying to attempt an offence with an ulterior element, of which there aren't lots, or conspire to commit an offence with an ulterior element. This is a problem that applies to every single inchoate offence, or every offence where you have this multiple event structure. So let's have a look at it briefly. So definition of mens rea terms, I put a number of them here. This is sort of paraphrased from generally how these terms are defined either in the common law or in various criminal codes. So we talk about voluntariness as the defendant's actions or omissions are voluntary if they're willful or volitional. So let's start there. Let's say we have an offence, a simple conspiracy. You and I are agreeing with one another that we're going to kill somebody in the future. So we now need to think, okay, we understand what it means to intend our agreement, the T1 bit of the offence. But then we have to think about what does our mental state have to be in relation to that future crime, the murder that we want to commit in the future. So if we think about the act part of that, the physical bit, I'm planning to shoot somebody, let's say, in the future. I have to be voluntary in relation to that shooting. But if voluntary is about being volitional or willful, I can't be volitional now in relation to action in the future. That doesn't make sense. I can be volitional now as to what I'm doing with my body right now, moving my hands around, but I'm not being voluntary as to something in the future. That's just something I'm planning. So the word voluntary doesn't seem to work. What seems more natural is to say that I have to intend to act in the future. But intention is problematic as well. Again, if we look at the definitions within standard criminal codes, we're talking about a defendant intends if they act in order to cause something to come about, or if they act knowing that it's a virtual certainty that it's going to cause something to come about. But again, that doesn't fit to my scenario. I don't act now when I agree with you in order to cause the killing in the future. There's no causal link there. I might commit myself in some way to killing somebody in the future, but I'm not causing myself to. I know there will be a point in time at the future where I will choose whether to kill that person or not. I'm not choosing now, I'm merely committing to doing something. So all of these terms don't really fit that scenario, and yet these are precisely the terms that are used routinely within the common law, within criminal codes, within the construction of these crimes. So the point here is, again, one about really understanding the structure before we can understand the normative debate. Equally, when you think about the other elements of the future crime, the results, the killing of the person, the circumstance that it is a person, again, intention, recklessness, knowledge. How can I have a true belief now as to something that might be factually different in the future? All of these terms don't work. And so this is where I focused a lot of my work on sort of developing this idea of the difference between mens rea terms in relation to single event offences and mens rea terms as they can possibly apply to future events. One of the first things I worked on for quite a while was so-called conditional intention. And this is where the courts have become particularly, got themselves in all kinds of knots, particularly around complicity. So the Supreme Court in the case of Jogi, some of you will be familiar, talked a lot about conditional intention. But they were talking about a defendant conditionally intending to assist or encourage. And that simply doesn't make sense. I can't conditionally intend to assist or encourage you. I either am insisting in encouraging you, in which case I've intended to do it. There might have been choices, conditions in the past, but in action I'm resolving those conditions. I'm choosing to assist or encourage, or I'm not. So conditional intention as to present conduct doesn't really make sense. It makes sense, incidentally, in German law, where it means something very different, and that's also distracted a number of scholars. But in English law, it doesn't make sense. In US law, it doesn't make sense. Where conditional intention does make sense is if we think about my commitment to the future action. If I'm agreeing with you now that I'm going to kill somebody in the future, then that intention will be necessarily conditional. If you were to ask me, will you still kill them if you find out they're already dead? No, I won't. Will you still rob the bank if you see that it's surrounded by police with a sign saying, we know you're coming? No, I won't. So it's implicitly, if not explicitly, going to be a conditional intention to do something in the future. So conditionality becomes problematic if we plug it into the law and assume it applies everywhere. But if we recognize the difference between single event offences where it doesn't work and future offences, T2 type offences where it does, that's where it begins to make sense. Similar thing with an article which I wrote with Adrian relatively recently. This applies across all elements of the crime. So that focused very much on my conduct, the conditional intention to act at all. But the same is true in relation to the acts, circumstances and results of that future offence. For each one of them, if we're going to make sense of these mens rea terms, we need to either abandon them and have brand new terms that understands that future offence, or we have to redefine them in relation to that future offence. In the same way, incidentally, that many criminal codes have definitions of what intention means as to circumstances and as to results, they need to have that also in relation to future circumstances and future results. And only that way do these terms make sense in that context. So again, the theme here is that understanding the structure is necessary in order to engage with and then in order to understand the debates. We shouldn't be debating, as the law too often does, and certainly the courts do, whether we should require intention or recklessness for inchoates. What we should be debating is what those terms mean in relation to the future offences, and only when we've resolved that debate can we have a sensible normative debate about actually which one we should be choosing. Particularly here, for example, I've casually talked about intending a future offence as being committed to that future offence. But what does the word commitment mean? We don't have that debate because we haven't recognised the two-step structure demands us to have that debate. So that's where the scholarship should be, rather than arguing over fault terms that simply don't fit. Okay, next up then is complicity. So as our second sort of example of a similar theme. So complicity is a little bit like inchoate, assisting, encouraging. The T1 bit is our defendant assists or encourages another party. But importantly for complicity, the future offence must actually happen. So at the point where the future offence does happen at T2, our defendant is now no longer simply inchoately liable for assisting and encouraging. They are now complicit in that crime. They will be labelled and punished as a principal offender. Now, when we think about complicity, we have some of the same problems again. So we have the same problem in terms of mens rea terms. So debates in relation to complicity will often focus on, must our defendant intend the future crime? Must they, what does it mean to know the essential elements of the future crime? So that's the case Johnson and Yoden that goes way back. And there's been debates, perennial debates, about what does it mean to have knowledge of the elements of a crime that hasn't happened yet. But that's where the debate tends to focus. But again, it's the same problem. Those terms simply don't fit that future context. And so the initial debate should be one about what do these terms mean? What could they mean? What should they mean in relation to future crimes? And only then can you unlock the normative debate about which one of the terms we should be choosing. Incidentally, there's an associated problem here as well, that for complicity, it's not that I'm committing myself to commit a crime in the future. I'm assisting or encouraging you to commit the crime in the future. So even the way I defined what it might look like to intend my own future actions, that doesn't fit to this context either. I can't commit at T1 that you will commit a crime in the future. That doesn't make any sense. I can't commit to a choice that you're going to make and I'm not going to make. So here, when we're talking about intention as to somebody else's conduct in the future, I'm not causing it by my present conduct, so the standard definitions don't work, but the commitment model doesn't work either. Rather, what we must be talking about is something more akin to a sort of bare intention, a hope, an endorsement maybe. But again, that's where the debate should be. What can and should this term mean when we're talking about intending somebody else to do something in the future? Another one here is that we now have actus reus, the physical element aspects as well. So unlike the inchoates, as I said, for complicity, that crime must actually happen. Now, this is also an area which has caused lots of problems about the role, particularly of causation. So a number of courts and some academics argue that there's some kind of causal explanation for what's going on in complicity. I'm to blame for your crime in the future because I have caused your crime in the future. Now, the natural and obvious response to that is to say, well, actually, as we understand the word causation, you simply haven't caused someone else's crime. They have made a choice whether to commit a crime in the future, and that free and voluntary choice will always break the chain of causation. So in the standard way we understand in criminal law the term cause, it doesn't fit to that context, and so therefore causal accounts are often dismissed on that basis. My argument here is, why should we tie ourselves to the single event definition of a term like causation? In exactly the same way that I'm encouraging that we redefine terms of mens rea in order to make them fit, it's perfectly rational to talk about causation in the context of a future crime in a slightly different way, with a different definition. We just have to recognize the fact that it's structurally distinct. So when John Gardner and others talk about indirect causation or quasi-causation, that may well make sense, not as a redefinition of causation within the present fault paradigm, but as a redefinition of what we mean, or a definition of what we mean by causation in relation to multi-event offences. There's a similar thing in relation to so-called fundamental difference, or post-Jogi we now call overwhelming supervening events. Essentially, this is the idea that if I assist or encourage you to commit a crime, but you do something that's really very different from what I've assisted or encouraged you, then that can sever my link to your crime, and therefore I'm not complicit in it anymore. So if I encourage you to punch somebody and you actually shoot them, then you commit murder, but I don't, because that's something that's really very different from what I've encouraged you to do. Now, courts have been always very uncomfortable about this rule, because it only really exists in relation to complicity, and it's seen, therefore, as something of an anomaly. Indeed, in Jogi, the Supreme Court went as far as to say, in getting rid of what was called joint enterprise, we don't need this rule at all anymore. At least we need it in a very few occasions, only if there's a change of victim, for example. And academics have leapt upon this, and most recently a work in progress, which will be published shortly by Simister and Stark, have argued that actually it is completely anomalous now, and we should simply get rid of this rule. Post-Jogi, we don't need it anymore. But my argument here is that why is it anomalous? It's anomalous, yes, in the context of a single event crime. It's anomalous to talk about, once I've unleashed the threat, once I've planted the time bomb, the fact that something different happens later on is neither here nor there. I'm responsible for it. So we don't think about things like fundamental differences somehow breaking chains of causation. But my argument is that this isn't the same as the single event analysis. Across multiple events, it seems to me entirely rational to say, what is it that the defendant has committed themselves to at T1, and how different is that event that happens in the future? And by the way, this is not something that would just apply to joint enterprise as the courts have historically associated it, but it makes complete sense to me in relation to complicity, and indeed in relation to prior fault that we're going to go on to look at in a moment. And again, it's recognizing that some of these rules make sense in the context of one structure and not another, and then having the debate focused in that way. This is something I've written on a little bit. This was with Bob Sullivan, mainly around conditional intention and a critique of Jogi in this paper. But it's definitely something that requires some further work in the future. The last area I want to look at is so-called prior fault. So prior fault takes a little bit of explanation, first of all. But essentially, there's kind of two mechanisms whereby prior fault comes into play. The first one is about prior fault and the construction of a crime. So the defendant lacks mens rea at T2, so this is when they're causing harm, or they might be entirely involuntary in their behaviour due to prior fault from an earlier time, T1. The law essentially allows that prior fault at T1 to come along and plug the missing elements at T2 to create an offence that's taking place now at T2. The easiest way to understand it is in relation to intoxication. That's the kind of paradigm example. So I get blind drunk voluntarily at one point. I then stagger home and break something that belongs to somebody else. Now I can rationally say, if you think back to criminal damage, it requires intention or at least knowledge that I might be breaking something belonging to somebody else. Now, I might rationally say, I was blind drunk, I had no idea what I was doing, I didn't foresee a risk of breaking anything, please let me off. The law steps in there through this rule of prior fault and says, tough luck. You got yourself in that position at time number one when you became drunk, therefore we're going to essentially pretend you were in fact reckless at T2 even though you weren't, and we're going to label you and punish you for criminal damage even though there were elements missing. So again, we're finding liability by plugging together two different events, two different points in time. The other way this applies is prior fault and the blocking of defences. So this is where it looks like our defendant has a defence, but something that they've done previously essentially undermines their ability to rely on that defence. So a classic example would be a sort of grand schema type case where our defendant decides, okay, I want to kill my friend, but I don't really want to go to prison for it. So what I'm going to do is I'm going to antagonise them until they eventually attack me. And when they attack me, I'm then going to kill them in self-defence. And I can rely on self-defence and I can get away with murder. So in that scenario, if we just look at the end bit, the friend attacks, you kill, you may well say that that satisfies the elements of self-defence and should lead to an acquittal. But you go back essentially to the point before, the intentional antagonism, and you say that no, that prior fault undermines the ability to rely on the defence. So again, two events plugged together in order to find liability. Okay, so that's the explanation, and this is an article which I wrote, which was just around sort of mapping how these different prior fault rules work. Now, prior fault's interesting. It's interesting, first of all, because here there really is quite a fundamental lack of structural or functional analysis, of really understanding how these rules are working across these two events. We have some acknowledgement of how the multi-event offences work for inchoates and complicity. Real problems, as I say, in the execution of it, but at least that basic structure is understood. For the prior fault rules, much, much less of that. And so a lot of the work has been about really bringing home how that structure fits together. So you have the so-called intoxication rules, the examples of which I gave you, which is traditionally been sort of mispresented as a defence. So the idea that I'm so drunk, therefore I can't rely on that as a defence for exculpation. Now, that doesn't really make sense, because at T2 I wasn't relying on a defence. I was saying I didn't commit the crime. I lacked the mental part of the crime. So it's always been a fiction, but that's been a way to kind of misunderstand or confuse essentially what's going on. That's now reasonably well recognised, at least academically. Sometimes the courts still fall on the description of defences, but academically most accept now that this is a T1, T2 multiple event sort of construction of liability. What is less well understood is that the same structure applies elsewhere. So I've written on the automatism rules as well. So automatism is where our defendant lacks voluntary conduct, essentially. And just like intoxication, automatism and is still standardly referred to as a defence, but it never applies as a defence. It is always a denial of the crime itself. I'm involuntary, therefore I didn't commit the crime. There's no search for a new defence, that's what's going on. And so if we're dealing with rules in relation to prior fault automatism, we're again dealing with constructions of crimes. I didn't commit the crime at T2 because I was involuntary, but we're going to blame me for it anyway because my prior fault at the earlier point is used to substitute for missing elements. Also another paper on a similar kind of theme around the voluntary act requirement. Also written about similar themes in relation to insanity. So the insanity rules are again classically understood as a defence, but at least in many of the ways that they apply, they're applying to defendants who lack mens rea or have an alternative defence. So when these defendants are caught within the insanity rules, this isn't a route to exculpation, this is a route to being trapped within a diversion system that can lead to their compulsory detention. It can be described as an inculpatory rule. This was a paper first exploring that with Bob Sullivan, and a more recent one that will be published soon with Claire Hogg. I've also written with Hans in the group here and others in relation to this in terms of defences. So a defendant who is denied the ability to raise self-defence because of a mixture of what might be understood as an intoxication or a mental disorder leads to the disapplication of a defence. Now, the reason I've gone through each of these and why this is a problem is because the focus of the law, certainly in the courts, and indeed much of the academic commentary as well, is analysing these things as defences. Should we allow the defendant the defence of automatism, the defence of insanity, and so on? But that is the wrong debate. If we understand the structure of what's going on and we understand that these are actually rules that inculpate, they don't exculpate, then the debate shouldn't be about when we allow a defence. The debate should be about criminalisation. At what point is this T1, T2 structure a justified route to criminalisation? And that fundamentally changes the debate that we're talking about. We also have a similar issue now in terms of fault. So this isn't quite about the translation of mens rea terms as we've talked about before. This is the basic idea that if we accept that this structure for prior fault is some kind of fault at T1, drunkenness, prior fault automatism, or whatever it might be. And if that's being used to substitute for missing elements at T2, then we need a direct equivalence. It's not fair to criminalize and to label somebody in a certain way at T2 if the missing elements aren't at least equivalent to those that are being used to plug that gap. But if we begin to understand and unpack that, you realize that the law here is really on a pretty bad footing. So the law at the moment on intoxication understands something of this and makes a distinction between so-called basic intent offences and specific intent offences. So my prior fault intoxication can only replace a lack of mens rea for some crimes and not others. But the distinction there is not well theorised, and it's certainly not consistent. The Law Commission did a slightly better job of this, where they tried to go element by element of crimes and say, broadly, what we're dealing with for intoxication is the same as recklessness at T2. But that equivalence was always problematic, and this was my first academic article, incidentally, talking about why that equivalence doesn't stand up to analysis. We're talking about somebody who is, at most, objectively negligent in their behaviour and getting drunk at one point. And to say that that is directly equivalent to foresight of a particular risk and going on unreasonably to run that risk in action is a massive leap that isn't justified appropriately within the work of the Commission. Others have gone slightly further. Gideon Yaffe, I think, is probably the most developed theory in this area. But again, there's problems. He would narrow the idea of prior fault here by saying you must at least have some kind of recklessness at T1, and therefore we can say you're reckless at T2. But again, that misses the point if you accept the earlier argument that recklessness at T1 doesn't mean the same thing as recklessness at T2. So falling back on some of those problems of those building blocks, again, affect what we're dealing with here. So what we end up with in relation to this second problem is that, yes, we might agree intuitively that there should be some kind of criminal liability, perhaps, where someone gets blind drunk and then causes harms. But to label someone and punish someone for a crime they haven't committed requires a form of equivalence that isn't well expressed or hasn't been convincingly expressed. And so this takes us to a third issue, which is, okay, if we're going to go down that line, then we have to think about what the law should require here. And we've started looking at the potential for, could you construct a crime, a new offence, which does accurately describe and does accurately punish for what the defendant has done, that explicitly engages with what's required at T1 and then required at T2. But as soon as you do that, and it's been theorised for a number of years, different academics have tried it, but as soon as you start down that line, you realise that we lack the building blocks, all the way back to the problems with Inchoate and with Complicity. It's those same problems again. We don't really understand what we're blaming someone for at T1 when they're getting drunk. We don't understand what it means to have certain mens rea terms because we haven't defined those mens rea terms in terms of T1. We don't really understand what it is that we're blaming them for in terms of their conduct either. Is it about quantity of alcohol? Is it about circumstances of alcohol? Is it foresight at that point or whatever? So again, we need to start really understanding and creating those building blocks before we can have a sensible debate about what our offence should look like. And this is where a lot of my work most recently has been. So again, with Hans in the front here, talking about how we can reach out to the sort of behavioural neurosciences to start helping legal theory build some of these blocks about understanding what it is when you're intoxicated, what we can rationally blame someone for, what we can think about in terms of mens rea and at what point. And similarly, looking to other jurisdictions. So there is a gross intoxication offence within Germany, although it's built very much on blood alcohol levels. So one, it's isolated to just intoxication, not other forms of prior fault. And also we might question whether we want to structure an offence in this way. But we have to look into it because, as I say, we lack the tools under the current law. So it's looking for other potential areas that we can develop those tools, the so-called descriptive part of the general part, descriptive element of the general part. And this is something that, again, written a few papers on, and it's the topic of the current monograph project. And that kind of brings me to the end. So the thesis that I wanted to get to was this one, that in order to, we need to understand the understanding of the structure and function of legal rules, although it's not necessarily the most glamorous area always. It's a necessary precursor to get onto the debates that we often want to have. And it's an essential precursor for the courts before they really can start applying terms, is to think about whether those terms make sense in the structure of the offence that they're dealing with. And the argument across each of these three areas is that the current terminology doesn't. The descriptive general part doesn't provide the tools necessary. So it's only when we start to unpack that and we stop trying to simply transpose single event definitions into multi-event crimes, it's only then that we can have sensible normative debates, and indeed only then can we start to consider rational routes to law reform. Okay, that's me. Thanks.